So this is a little bit more about Maximus. Maximus administers this appeal process or this arbitration, and the first thing you would have to do is set up an account with Maximus. Now, this is only if you're doing it yourself. If you're using an attorney, they're going to have their own account set up, and they're going to be the ones filing for you. Now, you have 90 days to file from the receipt of the internal appeal denial. So after filing that DOBI Form 352, once you get the response continuing the denial, you only have 90 days. So it's not like PIP where you have 2 years from the date of last payment. It's only 90 days, so it's a very tight time frame, and you really have to be on top of things to get things over to your attorney or to appeal it yourself to Maximus. Now, Maximus then has 30 days to respond, so they're going to issue a determination within 30 days, but they can get one additional 30-day extension if they're not done in time. Now, one of the kickers here is there has to be at least $1,000 an issue. So for E&M and modality claims, you're going to have to actually aggregate a bunch of these claims together, and you are allowed to aggregate together if you need to. So basically, if you have to, you can go forward and you can put together a whole bunch of denials on different patients based upon one CPT code. So if you have a whole bunch of 99213s denied, you can aggregate them together to reach that 1,000. Now, one of the big drawbacks about Maximus is the fee. Basically, you're obligated to pay a $50 preliminary review fee, which is non-refundable. So when you submit your claim to Maximus, they're going to take your $50, they're going to cash the check, they're going to look to see if they're even going to take your case, and that money doesn't get given back if they don't take it. So at that point, they'll determine either, yes, this is arbitrable, or it's not, and then if they do state it's arbitrable, they charge you an additional $130 for the arbitration. But that is refundable if for some reason they kick it back thereafter. So you may get the $130 back if they don't go through the full arbitration process, but if you do go forward, you don't get that money back. So unlike PIP arbitrations, this is a hard cost you have to pay, and it's essentially an 18% cost of doing business here because it's $180 per $1,000 an issue, and you don't get that money back even if you win. Another limitation is you don't get attorney's fees back like PIP arbitrations. So if you have $1,000 at issue, you file an arbitration, you're paying $180 that you don't get back, and then the attorney who represents you is most likely going to take a contingency fee on it because there is no fee shifting or fee payment by the insurance company.
Jeff,
yeah.
How long do you have to appeal claims that are denied? I understand that you have 90 days to file this appeal to Maximus or go to the second level outside of Maximus once you have a denial from the first level, but how long do you have to appeal the first level?
It can vary by plan, but the general rule is 180 days. So,
okay.
But each plan can vary. So that's the rule of thumb, but you really do need to check each individual plan to see what the appeal time frame is. Okay, so if you're a non-par provider, we're here at the second level, so it's a non-medical necessity appeal. Essentially, what we can do is if you're participating, we have to go to Maximus, and we would proceed through that process we just talked about. If you're non-par, we have other options. We can go to Superior Court, and that's really dependent upon how much is outstanding and how much is at issue, essentially. We can go to small claims if it's $3,000 or less, which is a very quick process. It's relatively cheap. The filing fee is probably about $25. If it's more than $3,000 but less than $15,000 an issue, we can go to what's called the Special Civil Division, which is it's probably about a 3-month turnaround on that, and it's roughly about $50 in filing fees. So you're getting quick turnarounds. It's much cheaper fees than going to Maximus, and I think this is the best route to follow if you're non-par. Like I said before, if you're par, you may be forced to go to Maximus. And what I would need to pursue this claim for you, if you chose me as your attorney to go forward with it, is basically I would need to get a copy of your first level denial letter, which shows that you did that internal appeal with the DOBI Form 352, because that's our key to getting into either court or arbitration. Without that, we can't go forward. I would need a copy of your claim that you submitted to Horizon, a copy of the explanation of benefits, which showed the denial and the explanation code for the denial, which would most likely state that global reimbursement bundling, and then finally supporting documentation. So I would need your SOAP notes, I would need your E&M exam reports, just something to back up the billing that you did, because the one way you're going to lose these claims is if you don't support your billing with your documentation. So if I went into court with a bill for 99,214, an existing patient evaluation management, and you had one little scribble line of notes to support that, there's no way you're going to get paid for that. You have to have documentation to support that high-level E&M code, which showed that you did a history, an examination, and you had some comprehensive decision-making to make to support that claim. So, I mean, there's probably going to be a very high success rate on these as long as your documentation is good. If the documentation is there, there's no reason Horizon should win these proceedings because there's a DOBI order stating they have to pay for it if it's supported by the notes. Okay, and again, with a Maximus appeal, there's a 30-day response time. Usually if you're going to court, there is 30 days where Horizon would then have to have their attorneys file an answer or default, and a lot of times you will be sent to mediation by the court where we can settle these cases without having to go forward. Now, as I said before, unfortunately it's not like TIP where the insurance companies pay my attorney's fees if I win for you. Here, the only fee I can get is doing on a contingency basis, and for clients of Billing Precision, I'm giving a 25% contingency rate. My normal rate's 33 1/3, which most attorneys will charge, but I am reducing it for Billing Precision clients. So I mean, that's really the process we would have to go through. Once that internal appeal is done, I would just need to get this documentation, and then we can proceed either through Maximus or through either a civil litigation, as we discussed before. Okay, let's try to wrap things up. So where are we right now? Now, the ANJC, we're looking into retrospective reimbursement like I talked about. There's not much we can state right now, but we're not just giving up on those claims that were submitted before October 7, 2009. We think there's a viable action we can possibly pursue to get chiropractors some reimbursement. There's no real time frame that we can set down right now, but we're going to try to go back as far as we can to try to get reimbursement for chiropractors in New Jersey. Now, critical. If you take one thing away from tonight's webinar, you must file the internal appeal if they deny your payments. Okay, we have to, number one, prove that you did that appeal because that's our key to getting into either arbitration or going to court to get you paid for these claims. And also, the more appeals that you file, the more Department of Bank Insurance is going to know Horizon is disobeying the decision. And what I've actually done is we've gotten together about probably 40 to 50 different EOBs from Horizon since this decision on October 7th. We bundled them down, sent them down to DOBI, and that's really what triggered Department of Bank Insurance calling Horizon out in front of them to explain why they're not paying it. So these explanation of benefits, these appeals are critical in allowing us to go to DOBI and saying, listen, Horizon's still thumbing their nose at your decision and not paying. And then finally, we're going to hopefully be addressing Horizon's noncompliance with DOBI in the near future. So DOBI's meeting with Horizon. We've requested a meeting with DOBI after the meet with Horizon just so we can get an explanation as to, okay, how long is this going to take? When is Horizon going to implement some type of workaround so they're going to start paying these claims? So as more information comes, we'll keep you up to date. And with that, I'm going to turn it back over to Brian. Done presentations for the ANJC in all regions of New Jersey. We did one in North, Central, and South Jersey. And the consensus are most people actually screaming out of the meetings is, I am not appealing all these claims. I can't do it. I can't afford it. I can't pay my staff to do it. So I believe the majority of chiropractors are not going to be doing these appeals, which means without the appeal, they're flushing that money down the drain because you have to. It's a very set legal maxim that you have to exhaust your administrative remedies. You have to appeal, or else you're not going to get paid for these. There have been very big lawsuits which have been completely denied because of this failure to exhaust the appeal process.
Okay, stay tuned for part 4 of this webinar. Jeff is going to go into a little bit more detail, and also we're going to talk about what we've already done with Billing Precision and leveraging the network that we've built. We are actually looking at producing a 32,000-page document for all of our clients across New Jersey, and then also automating the process going forward. If you want to see that and how that's happening, just stay tuned and we'll go over that. And then the closing part of this webinar, which is only a couple more minutes.